Hi, I'm Denise, and you're watching Law with Denise. So you've heard your lecturer talk about consequential loss and pure economic loss, and you've heard your lecturer talk about this general rule with regard to recovery for damages for pure economic loss in English tort law. But you're not sure what they mean by consequential loss and pure economic loss, and you don't know what this rule is with regard to recovery for damages for pure economic loss in English tort law. Worry not. In this video, I will outline the difference between consequential loss and pure economic loss, and I will explain what this general rule is with regard to recovery for damages for pure economic loss in English tort law. And finally, I will explain why we have this rule for recovery for damages for pure economic loss in English tort law. So let's begin. Let's start with looking at what exactly consequential loss is. Now, if you've been studying negligence for a while, you do know what a consequential loss claim looks like. You may not have been told that this is a consequential loss claim, but you've seen them before. You've seen them many times. Let's have a look at a typical example. So let's make something up. Let's say party A is a negligent driver, and party A's negligent driving causes harm to party B. So it causes physical harm to them. And as a result of this physical harm, party B needs to pay medical professionals. Now, party B then starts a claim in negligence afterwards because they say they should be able to recover damages for this loss because it is as a result of party A's negligent driving why they ended up paying this money out. Typical, you've seen this before. Not only have you seen this type of claim, which includes a party who suffered physical injury, so injury to their body, but you've also seen these types of claims when the injury is caused to property. So we could have another scenario in which party A is negligent in some way and injury is done to party B's property, and party B has to pay out a particular amount of money, perhaps to fix the property, and then party B starts a claim and says that they think they should be able to recover damages for this because it is as a result of party A's negligence why in the end they had to spend this money to fix their property. This is a consequential loss claim as well. Now, what exactly is a pure economic loss claim? Because they look different. The main difference between a consequential loss claim and a pure economic loss claim is that with a pure economic loss claim, we will never be able to identify any injury to person nor to property. All we'll be able to identify is that one party is saying, hey, that party was negligent, and as a result of their negligence, I have lost money. So there is no physical injury, there is no injury to property that led to the loss of money. All we're going to see is negligence and loss of money, pure economic loss. Now let's have a look at a real case to get a good understanding of what pure economic loss claims look like. Let's turn our attention to Spartan Steel Alloys and Martin & Co. 1973. Now, I am only going to focus on claim 3 in this case because it's only the third claim in this case, which was a pure economic loss claim. If you're not familiar with the facts of Spartan Steel Alloys and Martin & Co., and you need to familiarize yourself with it in order to understand this discussion, I do have a video in which I summarize the facts of the case and the decision reached. The link is in the description. Now, let's look at claim 3 in Spartan Steel Alloys and Martin & Co. That was our pure economic loss claim. So what exactly was put forward in this claim? According to Spartan Steel Alloys, Martin & Co. were negligent in their drilling of the roads near to where their factory was. And as a result of their negligent drilling, they caused harm, or they dug into a cable, and Midlands Electricity Board decided that the necessary action that needed to be taken in order to resolve the issue created by Martin & Co. was to cut off the power supply in the area. This meant that Spartan Steel Alloys could not produce a certain amount of products that they said they would have normally produced during that time when the power was cut off. So they wanted back that money that they said they would have made had the electricity not been cut off. You can see that this is a pure economic loss claim because there is no mention of any damage done to Spartan Steel and Alloys property, nor to them physically. So yes, there was some harm done to a cable that I mentioned, but that was not Spartan Steel and Alloys property. So this is a pure economic loss claim. There is no injury done to the claimant, whether physically nor to their property. All the claimant can identify is that as a result of the defendant's actions, negligent actions, somehow they have managed to lose money and they want to recover that economic loss. Now, what is the general rule with regard to recovery for this type of loss? If we look at the decision reached by the Court of Appeal, in this case, Spartan Steel and Alloys and Martin & Co., we get our answer. Because in this case, the Court of Appeal said, no, you will not be able to recover damages for this claim because this claim is a claim for pure economic loss. And why not? Because they said the general rule is that recovery is not possible for pure economic loss claims in English tort law. Now we're on to our final question. Why do we have this rule in English tort law? Again, if we look at what is said in the judgment, we get a good understanding of this. The first reason is that contract law is where we turn to recover damages for pure economic loss, not tort law. And if we just have a look at what we have learned and studied in contract law, we will see that, generally speaking, this is true. When we get a contract law breach case, we don't tend to ask the client, oh, did you suffer physical injury? Not generally. Generally speaking, our main focus is what money did you lose? How much did you lose? We are concerned with pure economic loss. We're concerned with the money. That is not generally the concern of tort law. When we have a close look, we see that when we look at our foundational cases such as Donahue and Stevens, so we know that we're interested in the injury done to the person. So we're not just concerned about just purely money with tort law. When we look at defamation, we're looking at injury done to reputation. So this is our first reason. The courts are saying, this is not really the area of law that deals with pure economic loss claims. So generally speaking, we're going to say, no, you cannot recover it under tort law. This is not the area of law that is really put in place for such recoveries. And then there is another reason for this general rule on recovery for damages for pure economic loss in English tort law. This other reason is, as Lord Denning pointed out in his judgment in Spartan Steel and Alloys and Martin & Co. 1973, is that we are concerned with allowing or opening up the opportunity for far too many cases to enter the courts that potentially the judges will not be able to deal with. So Lord Denning pointed out that, okay, if we were to allow for recovery for damages for pure economic loss to be permissible in English tort law, we could have an issue of far too many cases entering the courts. And he said, in some instances, we might begin to realize that the facts of these cases are maybe not so true, and it will be difficult, he said, in some instances for the courts to even verify how truthful the facts of some of these cases are. So for those two reasons, the general rule with regard to recovery for damages for pure economic loss in English tort law is that recovery is not permissible. I hope that was useful. And until next time, please remember, take care and like, share, and subscribe.